Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. This is a special class intended for the interpretation students. Friends, yesterday in the class I told you the use of foreign decisions in the interpretation. You all know interpretation comes when there is any ambiguity, when there is any doubt, when you are not able to understand any proviso correctly. Then you have to refer to the interpretation, and it is definitely advantageous to the advocate. Foreign decisions, definitely they are useful for interpretation. Now the world is interconnected. Previously, our judiciary system almost it is similar to the England judicial system. Common law principles, international law, yes. So therefore, the use of foreign decisions plays an important role in arriving at a correct conclusion while drawing the interpretation. Right? Now, I will give you the object. Right? To start with the introduction, please remember, with the growing interconnected laws and treaties, the nations are mutually cooperating. Various treaties like UDHR, ICCPR, ICSCR, and European conventions, Geneva conventions, all these things, they are foreign decision treaties. We have to respect them. Here, please remember, according to Article 51 of the Constitution of India, you have to foster respect to international treaties. And before independence, our judiciary used to follow the judgment decided in England, basing on the common law principles. According to Article 372 of the Indian Penal Code, 372 of the Constitution of India, you have to take the common law principles as examples also. Of course, before independence, we are leaning on UK judgments, but after independence, we are more likely tending towards the American judgments. Best example is Marbury Vs Madison, which is the first judicial review case in 1803. So definitely, the foreign decisions will play an important role in our interpretation system, because in the process, judiciary of one country may follow the judicial decisions of the other nations and understand how they interpret the laws, the treaties, and the doctrines, etc. Right? Actually, even I can say Indian Constitution, it draws inspiration from the Bill of Rights, which are our fundamental rights, from the Constitution of America. Likewise, Ireland, DPSP. So many things are there. Definitely at the time, even at the time of drawing the so-called constitution, we have adopted the so-called use of the foreign decisions and other things. Now, I will give you a small examples, small case laws. Very first case I want to tell you is Justice K.S. Puttaswamy retired versus Union of India, that is Aadhaar judgment. Right to privacy before. So, Aadhaar judgment is definitely right to privacy. So this judgment was in 2017. In this case, please remember, the Supreme Court has cited a number of decisions from the European Court of Human Rights. Foreign decisions. Likewise, in the case of National Media versus Justi 1996. National Media versus Justi 1996. The South African Supreme Court, yes, there is a beautiful decision giving birth to a child without marriage. Yes, they are also valid. And take the example of Navtej Singh and others versus Union of India 2018. That is LGBT or same-sex marriage. It's allowed. Now Section 377 has been decriminalized, and this is actually our decision. This Navtej or Puttaswamy decision, they are being taken as in the Sri Lankan Supreme Court also. Sri Lankan Supreme Court cites our own judgments on homosexuality, like the so-called put others Aadhar judgment and also Navtej. Right? Please remember, these are the important things. So their case laws, the so-called Sri Lankan High Court case law is, Supreme Court case law is K. Ahatullah and two others versus state. The judgment was delivered on 24/2023. Likewise, Ashok Kumar Thakur versus Union of India 2008. This is Mandal Commission case. So definitely the foreign decisions, they play an important role. They are useful for the interpretation of the statutes. With this, I am concluding. Thank you very much.